Okay, so what we're doing today is talking about something that has been incredibly controversial and been a craw in the throats of many individuals, politically active individuals. What am I talking about? Affirmative action, race based affirmative action. And the Supreme Court has recently ruled on this issue. But the question is, what exactly did the Supreme Court say? Their opinion is over 200 pages. Who is going to read all that? Who is essentially confident enough? Who is interested enough to be able to go through all of that documentation in a short amount of time to bring you the answers? Me, that's who. Me, and I have the opinion right here, right now. Yep, here it is. So we're going to actually go through this opinion and see what it is that the Supreme Court held and why they held it. Okay. So essentially, the Supreme Court struck down race based affirmative action because they said it violated the Fourth Amendment of the Constitution. And they specifically said that Harvard and UNC's admissions program violated that. It started its analysis by looking at the very individuals or the group that brought the action. Now, the group is called Students for Fair Admissions, SFFA. And there was an argument that this was not a genuine membership or organization, which the court had to deal with. And it stated that effectively, yes, it was a genuine organization. So therefore, they could bring the suit. That was the starting point of the court's decision. And it talked about the whole idea of race-based affirmative action. What is it? Why should it be used? Is this still acceptable? Is this still acceptable? And ultimately concluded it was in no way acceptable because, in the words of the court, eliminating racial discrimination means eliminating all of it. Accordingly, the court has held that the Equal Protection Clause applies without regard to any differences of race, of color, or of nationality. It is universal in its application. For the guarantee of equal protection cannot mean one thing when applied to one individual and something else when applied to a person of another color. So they are essentially stating that even though the point of affirmative action based on race was to redress racial balances, it is in effect discrimination now in view of the majority of the court. And this was not a unanimous decision by any means. It was only 6-3. Now the court says that the court first considered whether the university may make race-based admission decisions in a deeply splintered decision that produced 6 different opinions. Justice Powell's opinion for himself alone would eventually come to serve as a touchstone for constitutional analysis of race-conscious admissions policies. And in dealing with universities' ability to look at different factors when they're admitting students, that ability, that freedom is not unlimited. Racial and ethnic distinctions of any sort are inherently suspect. Justice Powell explained, and antipathy towards them was deeply rooted in our nation's constitutional and demographic history. Furthermore, it stated that race could only operate as a plus in a particular applicant's file, even though it had been weighed in a manner flexible enough to consider all pertinent elements of diversity in light of particular qualifications of each applicant. What is the court saying? In plain English, race could be used as a bonus, but not to the detriment of an applicant. So, if there's an application and race is seen to work against an applicant, that, in the words of the court, is absolutely unallowed. That is not permissible in their eyes. So the court further on goes on to look at the Grotler case and states that the Rotter case and states that the majority analysis tracked Justice Powell in many respects, including its insistence on limits on how universities may consider race in their admissions program. Those limits, Grotter explained, were intended to guard against two dangers that all race-based government action portends. The first is the risk that the use of race will devolve into illegitimate stereotyping. So that is another issue with race, the fact that stereotypes can now be applied. So, for example, if you're stating that you're going to use race as a decision-based factor to admit people into universities or for any other particular dispensation that they'll be afforded, the problem with that is, are you saying everything about people of a particular race, and does that now lead to stereotyping, which is ascribing certain traits, behaviors, patterns to people of a particular race? And the court is stating that is not good. The opinion goes on to say that recognizing that enshrining a permanent permanent justification for racial preferences would offend the Constitution's unambiguous guarantee of equal protection, the court expressed its expectation that in 25 years, the use of racial preferences will no longer be necessary to further the interests approved today. 25 years have passed since Grotter, with no end to race-based college admissions in sight. Well, until this Supreme Court decision came out, that is. But the court has permitted race-based college admissions only within the confines of narrow restrictions. Such admissions must comply with strict scrutiny, meaning that there must be a compelling state interest, and may never use race as a stereotype or negative, and must at some point end. Okay, so then the court goes on to say that the respondents' admission system failed. So when they're talking about the respondents, they're talking about the two institutions in this case, the two institutions that were challenged by the Students for Fair Admissions, which were Harvard and the University of North Carolina, UNC. So the court goes on to say that respondents' admission system failed each of these criteria and must therefore be invalidated under the Equal Protection Clause of the 14th Amendment. And then it goes into explain why. It explains that the respondents failed to operate their race-based admission program in a manner that is sufficiently measurable to permit judicial review under the rubric of strict scrutiny. First, the interests that the respondents view as compelling cannot be subjected to a meaningful judicial review. These interests in training future leaders, acquiring new knowledge based on diverse outlooks, and promoting a robust marketplace of ideas, and preparing engaged and protective citizens. So what they're saying is that the application system of the schools were not sufficiently designed to allow any outsider to see if you could measure whether the objective that they set out is being met. The court then goes on to say that respondents at admissions programs fail to articulate meaningful connection between the means they employ and the goals they pursue. To achieve educational benefits of diversity, respondents measure the racial composition of their classes using racial categories that are plainly overbroad. So they're saying that the racial categories are so wide, you can't even tell who is inside the class. You can't even tell who they're admitting under the racial classification that they use. The university's main response to these criticisms is trust us. They assert that universities are owed deference when using race to benefit some applicants, but not others. While this court has recognized a tradition of giving a degree of deference to a university's academic decisions, it has made clear that the deference must exist within constitutionally prescribed limits. Respondents have failed to present an exceedingly persuasive justification for separating students on the basis of race that is measurable and concrete to permit judicial review, as the equal protection requires. So as you can see, the court is not a fan of race. They don't like using race in order for people to gain education. Clearly, this opinion strongly held that, and I have to constantly remind people this was not a unanimous decision. It was only 6-3. But certainly, the way that the court feels, their ideology is clear once you read this. And obviously, I'm not going to go into the whole judgment, but I'm just going to give you a few pointers. So it goes on to say that the First Circuit found that Harvard's consideration of race has resulted in fewer admissions of Asian American students. Respondents' assertion that race is never a negative factor in their admissions program cannot withstand scrutiny. College admissions are zero sum, and a benefit provided to some applicants but not others necessarily advantages the former at the expense of the latter. The court went on to say that 60,000 people applied to Harvard, 60,000, but only 2,000 are admitted. That shows how highly selected the program is, and that's why this is important in their view. So, furthermore, the judgment goes on to say that respondents' admissions programs also lack a logical endpoint as Grota required. Respondents suggest that the end of race-based admissions program will occur once a meaningful representation and diversity are achieved on college campuses. Such measures of success amount to little more than comparing the racial breakdown of the incoming class, comparing it to some other metrics such as racial makeup of the previous incoming class of the population in general to see whether some proportional goal has been reached. However, the court said the problem with this approach is well established. Outright racial balancing is patently unconstitutional. Wow. So the court is saying that that goal is not a goal that will stand up in law. So basically, a school cannot simply say that they're going to create a class that is racially composed of people of different backgrounds compared to the class of the previous year or compared to the general population in itself. That is not allowed. In their view, that is not acceptable. Okay. And the last part of the opinion is that it states that because Harvard and UNC's admissions programs lack sufficiently focused and measurable objectives warranting the use of race, unavoidably employ race in a negative manner involving stereotyping and lack of meaningful endpoints, the admissions programs cannot be reconciled with the guarantees of the Equal Protection Clause. So what the court is saying is that even if race was used, it cannot be tied to a measurable objective. It's not clear what the objective is. It's very hard to measure that objective. And it's also saying that the use of race is unconstitutional. It's unconstitutional. So, certainly, as stated before, the court is not a fan of race being used. Okay, so what is the overall takeaway from this? What's the overall takeaway? What's the view that people have, or I have on this particular issue? I see this as essentially the end of affirmative action for a while, especially when you look at the conservative liberal split of the court. It's clear that affirmative action, race-based affirmative action, may not be coming back in a long while. Should it have ended in the first place? The fact of the matter is, if you look at the history of African Americans and what they've been through in America, clearly there should be dispensation which accounts for the horrors that they've experienced. Absolutely. Affirmative action was designed to partly try and deal with that. The issue with that is, just as the court said this in its opinion, sometimes it's difficult to adequately assess what racial makeup or characteristics are constituted of in relation to individual people. How do you say, for example, if a person says that they're black, what do they mean by that? Do they mean that they're mixed with black? Do they mean that they have a black grandfather, etc.? So that's exactly what the court was trying to say. They were trying to express the fact that it's incredibly difficult sometimes to have a solid and accurate racial assessment of individuals. Secondly, the court was also saying that the idea of race has been used to penalize applicants. Fine. Okay. And the applicants in this particular instance, in view of the court, were particularly Asian applicants that were not allowed admission to Harvard and to UNC as a result of their grades. But if that is the case, if they feel race should not be used because it prevents other people from getting an accurate or a adequate chance at admissions into school, then in that case, there should also be a fair playing ground based on other factors such as legacy admissions. What is a legacy admission? It is that people who have been allowed to get into Harvard, into Ivy League schools, because they had somebody in their lineage, like a father, grandfather, who went to that school. And as a result of that, they gain admission. Also, if the court truly believes that race should not be used in order to assess university applications because it's unfair, in that case, people who donate to universities should not get extra dispensation and should not be more likely to be admitted because they have a grandfather or a father who has donated $2 million or donated a wing to his school either. In fact, couldn't an argument be made that the fairest manner of admitting students into school would be simply on a first come, first served basis if you meet the grade criteria? Or why have grades in the first place? This is the problem. The issue is that there will be some criteria that you have to use in order to differentiate candidates. Otherwise, why not have a first come, first serve? And should the criteria have nothing to do with the identity of the people? So you have to choose every applicant, even though they may get more opportunities based on the background that they are, based on the place that they live, based on the fact that they may not be grow up in a poverty-stricken household, or be in a crime-infested neighborhood, or be in a place where they should not be. You should ignore all of those factors and say you have to treat everybody the same. And even if the court is not saying so, even if people are not saying this, then again, I'll go back to my earlier point. What about the legacy admissions? Why not also take that away as a point through which candidates of lesser ability are able to game the system? So I'll leave you that to think about. Make sure to support the channel, support the stream by liking, commenting, and subscribing. And check out my other videos on this channel as well.